Hi, Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Attorney Alpha Carol O. Pontanal, and I am the consultant of BHRC for the development of its Gender and Development Ombud Guidelines. What are the guidelines about? The Gender Ombud Guidelines is a set of guides and tools on how the BHRC can dispense its mandates on the protection and promotion of women's rights. It is primarily for the use of BHRC staff, leadership, and management on its everyday work in the protection and promotion of women's rights. However, it is also to be followed by persons externally engaged by the Commission, such as deputized lawyers, translators, monitors, and volunteers. It may be used as a standalone document, but in order to maximize its use, it is advised to read it in conjunction with the BHRC Rules of Procedure and Guidelines in Monitoring Human Rights in the Bangsamoro, adopted in December of 2023. The Gender Ombud Guidelines is not the BHRC's Gender and Development Plan. It is a wholly separate and distinct document. The Guidelines is an evolving document, and we welcome your feedback, and we hope to consider it in the next versions of these guidelines. So, let me bring you back to the timeline of how these guidelines were developed. In September 11 and 2023, BHRC started with a leveling off meeting with the Bangsamoro Women Commission to know the issues that are faced by the Women's Commission in responding to the women's issues. In September 18 to 28 of 2023, we conducted a series of consultation workshops with different sectors in the BARM, such as ministries, offices, and agencies of the BARM, various sectors on the ground, such as indigenous peoples, religious and traditional leaders. These are both in mainland and in the Basulte area, members of the civil society organizations, also from the mainland and Basulta, as well as other sectors. In October 16 to 2023, we had an online survey among BHRC provincial directors and division chiefs to obtain their input on what should be included in the Gender Ombud Guidelines. After this, we had a meeting with the Gender Focal Person System to present the draft outline. That was in November 13, 2023. It was approved, and yours truly started writing the draft. In January 12, 2024, we conducted a validation and review workshop where I presented the first draft of the guidelines in a workshop among the staff of the Commission. Thereafter, in February 14, 2024, I presented the second draft to the Commission proper for their review and approval. And now, we have come to the launch of the guidelines. Where does the basis for BHRC's role as a gender ombud come from? This legal basis comes from the Charter of the BHRC, the Bangsamoro Autonomy Act No. 4. Under Section 28 of BAA No. 4, the BHRC is mandated to be the Gender and Development Ombud of the BARM. It says, without prejudice to Republic Act No. 9710, otherwise known as the Magna Carta of Women, the Commission shall act as the Gender and Development Ombud for the Bangsamoro. It shall undertake measures relating to the promotion and protection of women's rights under said law and international human rights instruments. So what are the mandates of BHRC as a Gender and Development Ombud? Section 30 provides for 5 major functions. Powers of the Commission as a Gender and Development Ombud and Children's Ombud. Pursuant to the foregoing 2 preceding sections, the Commission shall 1. Monitor the government in developing indicators and guidelines in compliance with their duties related to respecting, promoting, and fulfilling human rights of women and children. Number 2, investigate human rights violations relating to women and children. Number 3, establish guidelines and mechanisms, among others, that will facilitate access of women and children to legal remedies and related laws, and enhance the protection and promotion of their rights, especially those who are marginalized. 4, assist in the filing of cases against individuals, agencies, institutions, or establishments that violate the provision of the Magna Carta of Women and the Juvenile Justice Welfare Act. And lastly, number 5, recommend to the disciplining authority or the Civil Service Commission any possible administrative action based on non-compliance or failure to implement the provision of the Magna Carta of Women or the Juvenile Justice and Welfare Act. So the BAN number 4 requires minimum standards for investigation by the Commission. This is already reflected in the BHRC Rules of Procedure, but we should still highlight it for the Rules of Procedure in handling gender-based violence cases. So what are these minimum requirements? First, the rules should permit the victim or any other individual, group, or people possessing personal knowledge of the facts surrounding the human rights violations or abuse to file a complaint. Number 2, the rules should permit the filing of anonymous complaints. Third, confidentiality of the identity of the victims must always be upheld, including that of their witnesses and respective families. Fourth, there should be a provision for the citation for contempt. Citation for contempt is not covered by the rules on investigation of gender-based violence, as it is already covered by the BHRC Rules of Procedure. Lastly, BAN number 4 requires keeping a journal and records of the proceedings of investigation with due regard to matters that require confidentiality. Meanwhile, under Section 39 of BAN number 4, it says that the Commission shall make accessible all mechanisms for redress of human rights violations and abuse, and it shall adopt e-filing of complaints or reporting and provide a hotline open for 24 hours and make available personnel for this purpose. In the Rules of Procedure, this is done through the quick response teams. Such quick response teams is also provided for gender-based violence reports. So here are the components of the guidelines. The Gender and Development Guidelines of the BHRC for its gender ombud work is divided into 8 major components. First, the international normative and domestic legal framework on human rights protection and promotion for women. Number 2, legal basis of the BHRC gender ombud role in the BARM as previously mentioned. Number 3, the Bangsamoro context in which the BHRC operates. 4, its rules of procedure on investigation. 5, guidelines on monitoring. 6, guidelines and work plan to promotion of women's human rights. 7, approaches and guiding principles of the Commission in handling various gender and women's human rights issues. And number 8, the annexes. The first component of the Gender Ombud Guidelines talks about the normative and legal framework on the protection and promotion of women's rights. This part is composed of 2 parts. First, the International Normative Framework, where it lists the core international human rights instruments, such as treaties and various protocols to which the Philippines is a party, as well as various declarations on the rights of women. This also contains a short discussion on the foundational principles of the Convention on the Elimination of Discrimination Against Women, or CEDAW. It must be noted that while CEDAW is the only instrument that deals exclusively with the human rights of women, all of the human rights instruments encompass human rights of all persons, regardless of sex or gender. Meanwhile, Part 2 of the chapter looks at the salient points of national legislation related to women's rights. Among the laws highlighted in this part are the Women in Development and Nation Building Act, Rooming In and Breastfeeding Act, Anti-Sexual Harassment Act, Anti-Rape Law of 1997, the Rape Victim Assistance and Protection Act, Anti-Trafficking in Persons Act, Anti-Violence Against Women and Their Children Act, the Magna Carta of Women, the Safe Spaces Act, and the Anti-Child Marriage Law, among others. In the guidelines, you will find acts that are defined and penalized under each law, as well as obligations of the government in order to provide fulfillment to these rights of women. Part of our domestic legal framework on the protection of rights is the Bangsamoro Organic Law or Republic Act 11054. Bangsamoro Organic Law is the law that governs the establishment, grants of powers, political and governance structures and mechanisms within the Bangsamoro Autonomous Region in Muslim Mindanao. The BOL, as it is fondly called, is the outcome of years of peace negotiations between the government of the Philippines and the Moro Islamic Liberation Front that culminated in the signing of the Comprehensive Agreement of the Bangsamoro. It supplants and repeals Republic Act 9054, thereby replacing the now defunct Autonomous Region in Muslim Mindanao or ARMM. Compared to its predecessor, the BARM enjoys expanded powers under the BOL, and it is listed in Article 5, Section 2 of said law. Under Section 2, Powers of Bangsamoro Government, human rights is listed as among the powers that is within the competencies and functions of the Bangsamoro government. In addition, the Bangsamoro government also exercises power under the General Welfare Clause of the Bangsamoro Organic Law. So where does the Bangsamoro Human Rights Commission come in? The provision for a human rights institution in the Bangsamoro is provided under Article 9, Basic Rights of the Bangsamoro Organic Law. Section 6 states that the Bangsamoro shall fully respect human rights. Meanwhile, Section 7 provides for the establishment of a Bangsamoro Human Rights Commission in the BARM. It says that the functions, duties, and responsibilities of the Commission shall be provided by law to be enacted by the Parliament. It shall cooperate and closely coordinate with the National Commission on Human Rights. The statutory provision under BOL is operationalized through the Bangsamoro Autonomy Act No. 4, entitled the Bangsamoro Human Rights Act of 2019, also known as the Charter of the BHRC. Under Section 9 of the BHRC Charter, or BAA No. 4, the Bangsamoro Human Rights Commission, hereinafter referred to as the Commission, created under Section 7, Article 9 of the Republic Act 11054, otherwise known as the Bangsamoro Organic Law of the BARM, shall be the human rights institution of the Bangsamoro. As such, it enjoys a broad mandate to promote and protect human rights in the Bangsamoro and during armed conflict, uphold international humanitarian law. The Commission is an independent commission and guaranteed it shall not be subject to interference directly or indirectly from any government or private entity. It also enjoys fiscal autonomy, and it is prohibited to reduce the budget of the Commission from that of the preceding fiscal year. In the fulfillment of its mandates, the Commission exercises the following functions: promote human rights, protect human rights and uphold humanitarian law through investigation, monitoring, fact-finding mission, public inquiries, reporting the results of the same, and proceeding with prosecution when warranted. It can also advise the government at its own instance or upon request on the protection and promotion of human rights and international humanitarian law. It has the power to protect human rights defenders, act as a transitional justice mechanism, and perform administrative functions. So the gender ombud work of the Bangsamoro, as I have previously mentioned, can be found in Section 28 and 30 of the BAA number 4. However, the work of upholding the human rights of women is not exclusively borne by the BHRC. This work is shared also with the Bangsamoro Women Commission, an attached agency of the Office of the Chief Minister. However, given this sharing of functions, it is the BHRC which is considered by law to be the gender ombud in the BARM. In the process of development of the Gender Ombud Guidelines, we have also looked into the mandates of our fellow BARM agencies, insofar as these mandates provide opportunities for collaboration and complementation. We have seen that the Bangsamoro Women's Commission mandates are aligned as well with the mandates of the BHRC as the Gender Ombud in the BARM. First, the BWC is mandated to recommend policies and legislations to the Bangsamoro Parliament relating to women in coordination with concerned ministries, offices, and agencies. This is under Section 9, 1.5 of the BWC Charter. Number 2, it is mandated to monitor and assess the compliance of the Bangsamoro government on the CEDAW, UNSCR 1325, and all other international instruments to which the Philippines is signatory. This is under Section 9, 2.3. Third, the BWC is mandated to participate in the reporting to international bodies tasked to monitor implementation of the CEDAW and other instruments under Section 9, 2.4. Fourth, the BWC is mandated to refer specific cases of women needing assistance and interventions of Bangsamoro government agencies, national government agencies, and other stakeholders. And the fifth, it is mandated to work with law enforcement agencies, Sharia and regular courts, and other institutions and stakeholders to address gender-based violence and other women's issues. To prevent possible overlaps, it is hoped that a Memorandum of Understanding within the Bangsamoro Women's Commission and the Bangsamoro Human Rights Commission will be undertaken and signed. In the Gender Ombud Guidelines, you will also see a section on the Bangsamoro context. A lot of us are already familiar with the post-conflict context of the Bangsamoro, reeling from decades-old armed conflict that culminated in the signing of a peace agreement. The Bangsamoro is often characterized by its tri-people demographic pertaining to the Moro, Christian settler, and indigenous populations. This has given rise to a hybrid legal system of sorts, comprising of A. National and formal justice system, B. Sharia, primarily through national legislation such as PD 1083, and C. Indigenous codes and justice systems. In practice, these systems are not mutually exclusive and renders to some overlaps, especially when the parties concerned come from different communities. Within such systems, cases of gender-based violence are dealt with in varying degrees of gender sensitivity. In some areas, the payment of blood money for heinous crimes, including gender-based violence, eradicates the liability of the accused under traditional legal systems. Some instances of raid or clan feuds occurring between large and influential families and are characterized by escalating armed confrontations are sometimes settled through intermarriages. The culture of silence surrounding gender-based violence hinders survivors from coming forward and reporting such incidents. This is mainly due to the perception that sexual relations outside of marriage, regardless of the absence of consent, is a stain on family honor. This concept of honor, borne by the women on behalf of the family, coupled with low level of trust in the former and legal justice systems, contribute to the low level of reporting on gender-based violence cases. Even when survivors initiate filing of complaints, they usually withdraw or desist from pursuing the case later in the process. On women's political participation, Chairperson Hadja Bainan Karan of the Bangsamoro Women's Commission has cited in her State of the Bangsamoro Women Address that the BARM has 50.6% females among its population compared to 49.4% of males. And yet, women comprise a small minority of the leadership in the Bangsamoro government. In the Bangsamoro Transition Authority, 16 out of the 80 appointee seats are held by women. While women are found in technical and middle management positions in the civil service, the presence of women in leadership positions at the ministerial or deputy ministerial level is still few and far between. Meanwhile, while women are highly visible in local elective positions, they are more than likely to be members of political families. Much work remains to be done in ensuring women's political participation in all levels. This challenging context is the environment in which the Bangsamoro Human Rights Commission operates. It is hoped that with its appointment as Gender Ombud in the Bangsamoro, BHRC will strive to be the voice of women in the region, advocating for their meaningful participation in politics and decision-making, pushing for increased protection from violence, all in the pursuit of gender equality and justice. So we come now to the protection and promotion components of the Gender Ombud Guidelines. On protection, the protection component is divided into two: investigation and monitoring. For investigation, we have the rules of procedures in investigating gender-based human rights violation. This is composed of 8 rules, or Rule 1 to Rule 8. Rule 1 is on the general provisions. So, these rules are applicable to cases under investigation by the BHRC, including 2 main categories of human rights violations against women: discrimination against women and gender-based violence against women, as well as those with diverse sexual orientation and gender identity. So these rules aim to provide a safe environment for women victims of discrimination and gender-based violence, to give reliable and complete evidence, prevent re-traumatization, encourage women to report and participate in investigation proceedings by the BHRC. This also contains definitions on what is gender-based violence, what is gender-based discrimination, and what is intersectional discrimination. The rules on investigation are construed in favor of the protection of women throughout the investigation process. The provision of the BHRC Rules of Procedure in the investigation of human rights violations, adopted in December of 2023, are applied in a suppletory manner. On women outside the BARM, while these guidelines are primarily for the use of BHRC in the protection and promotion of women's human rights within the BARM, the BHRC will continue to undertake investigation, case monitoring, and legal assistance for human rights cases involving women outside the BHRC in coordination and cooperation with the Commission on Human Rights. The rules are subject to review every 3 years, subject to the discretion of the Commission. In such case, the Commission will consider the integration of these rules on GBV investigation with the overall BHRC rules of procedure. Earlier, I have mentioned about the provision of BAA number 4 regarding the establishment of 24-hour hotlines within the BHRC. Thus, Rule 2 of the Gender Ombud Guidelines provides for quick response teams. The primary responsibility of the QRT in situations of gender-based violence is to provide immediate assistance to the victim survivor of the GBV in order to preserve their life, liberty, or property that are in grave threat or imminent danger. The QRT or members of the QRT are required to respond in a professional and prompt manner. When receiving reports about GBV, the members of the QRT are required to respond through the following. They should thank the sender for sharing the information provided, ask them if it is all right to give them a call for the officer to ask further details. For non-anonymous message, inform the sender that in communicating with the QRT, the sender consents to processing his or her information. If time allows, the following information shall be obtained from the sender: name and contact number of the informant, name and location of the victim survivor, name of the perpetrator if known and relationship to the survivor, acts or omissions constituting the gender-based violence complained of, and the current domestic situation of the victim to determine urgency or need for rescue. It is also advised to close the communication by informing the caller or sender that the BHRC will take the necessary action to address the incident. The QRT should also advise the caller or sender to stand by in case BHRC needs to call him or her for other assistance. Upon receipt of the information, the QRT is required to coordinate with the VAU desk of the local police force or barangay peacekeeping action teams in the location of the victim for verification and appropriate action. Any refusal or inaction from the first responders, such as the BPAT and the police, shall be duly noted in the QRT report. The QRT is also required to ensure that the survivor is immediately referred to service providers for medical, legal, psychosocial, financial, livelihood, temporary shelter, and other forms of support through the BHRC GBV referral pathway mechanism. The investigating officer may likewise recommend in his or her initial evaluation report that the legal assistance to be provided by the BHRC or by partner legal institution is warranted or necessary. The case shall be subject to a 24-hour monitoring to ensure the safety and security of the victim survivor. Referrals made by the QRT shall be reflected in the case intake form of the case. On the BNP BHRC guidance note, in responding to urgent reports of the gender-based violence, the QRT shall be guided by the PNP Women and Children Protection Desk Regional Guidance Note on Prevention and Response to Gender-Based Violence in the BHRC, insofar as they are consistent with these rules. Investigators of the BHRC shall likewise refer to the guidance note when determining when police response to specific GBV cases have been conducted according to their own internal standards. We come now to Rule 3 of the Rules of Procedures in Investigating Gender-Based Human Rights Violations. This one is on initial evaluation. So the purpose of an initial evaluation is to determine whether a full-blown investigation of the complaint or case is merited. Some cases will come from the quick response teams. So the requirement is for the QR team to forward its report to the investigating officer on duty with recommendations and instructions on next steps to be taken. For walk-in complaints, complaints of gender-based human rights violations shall be immediately assigned to the gender focal officer or female investigator in the provincial office having jurisdiction over the case. Meanwhile, cases outside the BARM shall be referred to the Regional Office Protection Division. In case the victim survivor is hesitant to file a criminal case with the police or file a complaint with the BHRC, the investigating officer has the discretion to proceed with the investigation motu proprio in the following instances: extrajudicial killings, torture and sexual assault against women and persons of the diverse sexual orientation committed by state actors, gender-based violence committed in the context of armed conflict and in the context of displacement, death, torture, gender-based violence committed while in custody against women deprived of liberty. Fifth, killing of women human rights defenders or those with diverse sexual orientation and gender identity. These shall not be suspended by desistance by any complainant or witnesses, subject to rules for suspension of investigation under the BHRC Rules of Procedure. So, the initial evaluation part, or Rule 3 of these rules, also contains what are the required elements to be reflected in the initial evaluation report. I invite you to look at Section 8 of Rule 3 for these matters. The initial evaluation report are submitted to the Provincial Director for approval. Rule 4 deals with details in the investigation of gender-based violence cases. So, from docketing, upon approval by the Provincial Director of the recommendation to go into full-blown investigation, the docket number of the GBV case should bear the notation -GBV to tag it as a GBV case. This is done regardless whether the act is committed by state actors or private persons. Investigators must also be considerate of the status and feelings of the survivor of the GBV and must always remember the survivor-centered approach. What does this mean? It means keeping the needs of the survivor as the center of the entire investigation process. They shall ensure that the following rights of the victims are respected: right to be treated with respect and dignity, to be afforded privacy and confidentiality, right to be entitled to support services from different government service providers and private service providers, to be entitled to all legal remedies available and to be supported in accessing these remedies, to be informed of their rights and the services available to them, including the right to apply for protection orders, right to be heard, the right to be protected, to decide how to be involved in the process, and to complain when these rights are not respected. In the documentation and proceedings, it is also required for investigators to use aliases and for the documents and reports to not bear the real name of the survivor. So, the provincial office shall maintain a separate record containing the aliases and the corresponding real names of the survivors. Confidentiality of the highest level should be observed in investigating gender-based violence cases. Access to records of cases at the investigation stage should be limited to the investigating officer and his or her supervisor only. And the records are filed and stored in a separate location from the main case docket of the BHRC. On clarificatory conferences, as a rule for gender-based violence cases, clarificatory conferences where the victim or survivor and the perpetrators are required to meet face-to-face are discouraged. However, when clarificatory conferences are warranted, the investigating officer shall refrain from pursuing or encouraging conciliation or amicable settlement between the survivor and the perpetrator. And the investigator must remind the parties that mediation or efforts towards amicable settlement for GBV cases or VAUSI cases are excluded from the Katarungang Pambarangay Law. However, when in the process of investigation, the survivor and the perpetrator has quote-unquote reconciled or has reached an amicable settlement despite the investigation and support of the commission, this investigator should inform the survivor that she still has options to pursue the case and seek assistance. And the investigator will clarify with the complainant of the latter's interest in pursuing investigation of the case. If the complainant/survivor is still unwilling and still want to desist from pursuing the case, the complainant shall be asked to execute an affidavit of desistance. Effect of the execution of affidavits of desistance to cases under investigation. So if the complainant files an affidavit of desistance while the investigation by the BHRC is ongoing, the investigator should make sure that the complainant has made such an affidavit of desistance on her own free will, not because of force, intimidation, or duress. When the investigator is satisfied that the consent is unvitiated for executing such an affidavit, the investigator shall suspend the investigation of the case. And this will be noted in the final investigation report and made part of the record of the case. In the course of the investigation, the investigating officer should always make sure that the complainant or survivor has access to different forms of assistance. And this is done through the BARM GBV referral pathway. Even if the case has already been suspended or archived, the Commission shall continue to monitor any assistance provided through case monitoring. On the archival and dismissal of cases, if a case is suspended due to withdrawal of the complaint by the victim or survivor, it shall be archived for 5 years. After that, it shall be dismissed for lack of interest on the part of the complainant. Rule 5 is concerned with interviewing survivors of gender-based violence. The primary objective is to prevent re-traumatization of victims and survivors. So, if the investigating officer is already with the knowledge that the survivor has already been interviewed by a police investigator or social worker, the investigator will seek to obtain a copy of such report from the interview. If the investigator is able to obtain a copy of judicial affidavit signed by the complainant or comprehensive report, the investigator shall ask the complainant to affirm the contents of such affidavit or report without the need for another round of interviews. However, when there is no such document, the investigator shall proceed with the interview, however, taking care that the interview is conducted promptly, in a professional manner, and in a non-judgmental manner. Before obtaining any photos or videos, as well as taking notes during the interview, permission should be obtained from the interviewee. It should also be ensured that the interviewee, complainant, or survivor is not coerced or pressured into giving their consent for photo or video documentation. And it is not perceived to be a requirement for accessing legal or financial assistance from the Commission. As to the number of interviewers, the BHRC sets a maximum of 3 persons, including translator or photographer, in any interview session with GBV survivors. Staff should be unobtrusive as possible when taking photos or videos. Location of interviews. Interviews for GBV cases should always be conducted in a private area. So, in the provincial office, there should be a dedicated area for such interviews. For interviews conducted during field missions or outdoors, the investigator should make sure that the conversation between the investigator and the survivor is not overheard by third parties. Interviewers must, as much as possible, be of the same gender as the interviewee, survivor, or complainant. In closing the interview, the investigator shall summarize the points shared by the survivor or witness and verify whether it reflects the statements of the survivor, taking care to minimize re-traumatization to the survivor. We come now to the investigation of gender-based discrimination, which is another form of human rights violation against women, on Rule 6. So gender-based discrimination includes any distinction, exclusion, or restriction due to gender that has the effect of impairing or nullifying the recognition, enjoyment, or exercise of human rights and fundamental freedoms. This could be direct discrimination or indirect discrimination, and this could also be discrimination in law, called de jure discrimination, or discrimination in fact or practice, or de facto discrimination. These are all within the scope of this rule. Examples of gender-based discrimination are discrimination and non-recognition of the right to equal treatment before the law, discrimination on the right to access equal opportunities and assistance, and discrimination and or harassment in the workplace, training, or educational environment against women on account of their sexual orientation, gender identity, and expression. So how will the BHRC proceed with this? So first, the BHRC will look into the mechanisms that is present in the training or educational institution or in that workplace. So, in investigating employment, training, or education-related discrimination complaints, the investigating officer shall first ascertain the following. 1. Are there mechanisms in place to address issues, concerns, or complaints related to discrimination in the workplace or in the institution, such as a tribunal, grievance committee, or ethics committee? 2. Is the complainant aware of these remedies, or has she been informed of these mechanisms? C. Has the complainant been assisted in making use of these remedies? In case of the affirmative answer to those questions, did the individuals constituting such tribunals or mechanisms proceed in an impartial, independent, and non-discriminatory manner when dealing with the case? Next, are there members of such mechanisms or bodies who are trained in handling gender-related complaints? Did the institution make available any form of support to the complainant, especially those that will protect her from retaliation or further harassment? And lastly, does the institution ensure that all staff members have undergone gender sensitivity orientation training and awareness session. The Commission can also conduct fact-finding missions or site visits in connection with investigation of gender-based discrimination cases. Throughout this process, the complainant must be protected from retaliation. So the provincial office having jurisdiction over the complaint may recommend to the Commission the issuance of provisional remedies or preventive measures to protect the complainant from retaliation or from further harassment. Rule 7 on deputization of lawyers for gender-based violence cases. In deputization of lawyers to handle cases involving women, the Commission should ensure that the lawyers assigned to GBV cases have the necessary training on women-related laws and jurisprudence, and for this purpose, it should include in its pool of lawyers legal practitioners with background in handling cases involving women and gender. Rule number 8, the last rule, is concerned with the effectivity of the rules of procedure in handling and investigating gender-based human rights violations. So the rule shall take effect 2 weeks following its publication in the Bangsamoro Gazette, as mandated by the Bangsamoro Administrative Code. We come now to the second component under protection. So previously, we discussed rules of procedure on investigation. So now we come to the guidelines in monitoring women's human rights in the Bangsamoro. This part of the Gender Ombud Guidelines deals with monitoring of the following types. First, case monitoring. Second, facility monitoring for jails and facilities where women are deprived of liberty. Third is monitoring in situations of armed conflict, displacement, and humanitarian settings. Fourth is monitoring compliance of the Magna Carta of Women. And fifth, CEDAW and Human Rights Treaty compliance monitoring. For the monitoring of Magna Carta and CEDAW, this is shared with the Bangsamoro Women Commission. Okay, Chapter 1 on case monitoring covers 3 types of cases. First, cases referred to agencies for assistance. Second, cases assigned to deputized lawyers. 3, cases post-resolution by the Commission. Regular updates on the status of cases monitored shall be made at least every month or every after case conference sessions as may be applicable. And in case monitoring, the BHRC classifies responses into 5. So officers and units of the Commission who conduct case monitoring may also make use of this classification. So first, largely satisfactory response. 2, cooperative but incomplete response. 3, denial of responsibility but without adequate substantiation. 4, receipt acknowledged. And 5, no response. So this is also a different classification from status updates of each case being monitored. So Chapter 2 on facility monitoring, or monitoring the conditions of women deprived of liberty. So this chapter covers facility monitoring of jails, prisons, detention facilities, including those inside military camps, police lockup cells, youth homes, and any detention, rehabilitation, confinement, or other similar facilities, insofar as women deprived of liberty are concerned. So, for monitoring such cases, the officers of the Commission shall make use of the Bangkok Rules, also known as the United Nations Rules for the Treatment of Women Prisoners and Non-Custodial Measures for Women Offenders. The Bangkok Rules will be in addition to the Mandela rules that are already being utilized by the Commission, also known as the Standard Minimum Rules for the Treatment of Prisoners. So what are the conditions to evaluate? The monitoring officer shall assess the extent by which the following conditions are met, including the measures taken by the management towards their fulfillment. So the monitoring officer will look at 9 major areas. The living space, what is the current number of detainees vis-a-vis the declared capacity, conditions of the bed space, floor space, ventilation, bedding and sanitary facilities, and if there are other facilities available such as prayer area, library, etc. Whether the food is adequate to meet nutritional needs, and whether it is provided in usual hours and if there is variety. Is it responsive to varying health needs and religious considerations? And whether recently there have been reports of suboptimal quality or of food, such as spoiled food, and what are the resulting health issues from ingesting such food. Water and sanitation, and this is especially important for women. Ready access to sanitary and washing facilities, safe disposal arrangement for blood-stained articles, provision of hygiene items such as sanitary pads. Also, garbage disposal, sewage, and septic facilities. The monitoring officer should also look into bathing areas, whether these are afforded sufficient privacy. The monitoring officer should also look into the issues faced by vulnerable women, such as women with disabilities, elderly, and indigenous women. Under the Bangkok rules, health considerations for women are given extensive discussion. So, the officer should look into the provision of medical examination and health screening on entry or upon arrival, and measures taken to ensure medical confidentiality for detainees. Also, are physical and medical examinations conducted by women physician or nurse? And in case of physical examinations made by a male medical practitioner, whether women staff member are present or is present. On security, are measures taken to ensure that women are informed of rules and regulations, including filing complaints, whether searches are carried out by women staff with appropriate training, and whether for sanctions for non-compliance with the rules, whether deprivation of family contact is among the sanctions imposed. Are there measures to allow women to contact their families? And if families are going to visit, are there provision for child-friendly visitation areas or breastfeeding areas? There should also be provision for conjugal visits for married women detainees, but this should be consulted with the women in case there are considerations due to domestic violence or abuse. 8 is on access to justice. Do the women have access to information about their cases, including availability of legal assistance? Also, are they informed about their eligibility and status under the Good Conduct Time Allowance Law? Also, are the women given information about rules and regulations of the facility, including complaint mechanisms? And is there protection being afforded to women who report abuse? And lastly, we look at the capacities and training of the staff in the facility. Have they undergone or at least attended gender sensitivity training programs and orientation on the Bangkok rules? In the conduct of FGDs in places of detention, the monitoring officer shall ensure that such interviews are conducted in privacy or at least beyond the hearing range of detention officers, for them to have the freedom to discuss and share their issues. Out of the facility monitoring, there will be observations and recommendations. The monitoring unit of the Protection Division, with the guidance and support of the Policy Research and Advisory Division, shall draft human rights bulletins or advisories related to the situations of women deprived of liberty that were surfaced during the facility monitoring missions. Okay, Chapter 3 is concerned with the monitoring human rights of women in situations of armed conflict, displacement, and other humanitarian settings. So, for this type of monitoring, we refer to the normative standards in international law when it comes to the rights of women in humanitarian settings, such as the UN Security Council Resolutions 1325, 1820, 1888, 1960, and 2122. Also, we make use of the UN Guiding Principles on Internal Displacement and Republic Act 9851, or the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and other crimes against humanity. So, under Section 2 of this chapter, we have listed the various human rights violations that may occur in humanitarian settings. So, we invite you to read through this section. It contains 14 some examples of HRV against women during humanitarian emergencies. So, for monitoring staff, they are required to make use of an IHL monitoring form that reflects all of these information. Okay, and the IHL form will feed into an IHL monitoring report. So for staff of the commission, please look at this section as well to guide you in what should be contained in the IHL monitoring report. So this chapter deals with monitoring the situations of women in general, in a given locality or in a given situation. It still does not talk about investigation of specific cases. When there are specific human rights violations that are surfaced during investigation missions, the investigator leading the monitoring team is required to initiate an investigation motu proprio. Such investigation should be in accordance with the applicable rules of the BHRC Rules of Procedure. Chapter 3 talks about monitoring situations of women in specific situations, such as humanitarian emergencies. It does not yet talk about investigating human rights violations occurring in these situations. When there is a finding that violations of human rights of women have occurred in situations of displacement or emergency, the monitoring officer, the investigator leading the monitoring mission, shall initiate an investigation motu proprio, and this investigation will now be covered by the rules of procedure of the BHRC, as well as these supplementary rules in the examination of GBV cases. In displacement contexts, state authorities or government authorities are called upon also to mainstream gender in their work, whether it's humanitarian relief, recovery phase, or reconstruction and rehabilitation phase of the emergency. So we have listed here different measures by which the human rights of women will be protected during those three different stages. So we invite you also to look at it. Okay. On the composition of the monitoring team, to maximize resources and time spent on field monitoring so that they do not have to go back and forth, monitoring teams conducting field monitoring missions shall have members assigned as either focal officers for children or focal officers on gender-related issues in displacement. Also, the Commission, at its discretion, may authorize the conduct of public inquiries into situations affecting the human rights of women in situations of armed conflict or displacement. And these are covered by Rule 8 of the BHRC Rules of Procedure. Chapter 4 deals with monitoring compliance by the Bangsamoro government of the provisions of the Magna Carta of Women. This is listed under the mandates of the BHRC as the Gender Ombud in the Bangsamoro. However, this duty is shared with the Bangsamoro Women's Commission. So, the BHRC adopts a coordinative and collaborative approach as to this mandate. The BHRC is not prevented from producing and publishing its findings and reports independent of the BWC or other government agencies. So what are the areas to be monitored or assessed under this type of monitoring? Those areas are listed in the Magna Carta of Women, and we have reproduced them in this chapter. So please feel free to look into section 3 of chapter 4 of the guidelines on monitoring. Aside from monitoring the issues and concerns of women as a sector, the BHRC is also empowered to look into the situation of various vulnerable and marginalized sectors within the bigger sector of the women, such as girl children, senior citizens, indigenous women, Moro women, women with disabilities, women in the military and security sectors, small farmers and rural workers, fisher folk, urban poor women, women workers in the formal and informal economy, women migrant workers, women solo parents, women in sports, in film, media, and women of diverse social orientation and gender identity and expression. So we have also proposed a section on the phases of monitoring, but again, this will have to be tackled together with BWC. With regard to indicators, we have looked into the publication of the Philippine Commission on Women called the Compendium of Gender Equality and Women Empowerment Indicators. These set of indicators should be refined and contextualized to fit the Bangsamoro, and it is hoped that this will be done soon together with the Bangsamoro Women Commission. Through its Policy and Research Advocacy Division, the Commission is going to keep abreast of the latest developments in legislative and policy discourses related to gender and development. This is part of its legislative and policy monitoring. So for this purpose, it shall regularly monitor bills filed within the national legislature as well as the Bangsamoro Parliament for bills related to human rights and gender and development. So, if there are bills related to women's human rights, they will be bringing that to the attention of the chairperson so that it can be decided whether these will warrant the issuance of public bulletins or position papers. Chapter 5 deals with monitoring the Bangsamoro's compliance of Philippine treaty obligations under international human rights instruments, one of which is the Convention on the Elimination of Discrimination Against Women, or CEDAW. So again, the approach of BHRC is a complementary role to the work of the Bangsamoro Women Commission, which in its charter, or BAA number 8, has the primary mandate to monitor and assess the compliance of the Bangsamoro government on CEDAW, UNSCR 1325, and all other international instruments to which the Philippines is signatory. However, in view of the broad mandate of the BHRC as an independent human rights institution in the Bangsamoro for the protection and promotion of human rights, including advising the government, nothing in these rules should prevent the BHRC from pursuing its mandate of assessing compliance of the Bangsamoro government of all human rights international instruments to which the Philippines is signatory. In construing the provisions of international treaties, when the treaty make reference to state parties or state obligation, the word state shall be interpreted in the Bangsamoro context to mean the Bangsamoro government, including all its instrumentalities. So when do we conduct treaty compliance monitoring? Monitoring of the Bangsamoro's compliance with the CEDAW shall, as much as practicable, be aligned with the scheduled reporting period of the Philippines to the CEDAW Committee. In starting its work on treaty compliance monitoring, the BHRC will produce a document called a core document or a baseline document. This serves as an overall backgrounder of the Bangsamoro human rights protection framework. It contains general information on the Bangsamoro, for example, land, political structure, general framework for protection of human rights, such as laws and policies, and issues on discrimination and equality, including remedies for such. There is an outline recommended for the core document listed in Section 4 of Chapter 5. Again, in view of the concurrent mandates of the BHRC on monitoring and assessment of Bangsamoro compliance with the CEDAW, this work is complementary to the work of the BWC. When it seeks to obtain information in pursuit of this mandate, the Commission, through its chairperson, shall issue the necessary letter requests to other Bangsamoro government agencies to obtain the information necessary to complete its report. Lastly, on coordination with the Commission on Human Rights of the Philippines, the BHRC shall actively and regularly engage with the National Commission on Human Rights for sharing of information on the status of compliance with the national human rights obligations and commitments. And this is set out in Section 46 of the BHRC Charter. The policy unit within the BHRC shall coordinate with its corresponding unit with the CHR on reporting process, formatting deadlines, and other matters for the BHRC contribution to the CHR report or alternative report to the treaty monitoring body, and it shall maintain a calendar of deadlines for national reporting. As previously discussed, BHRC has two main functions: protection of human rights and promotion of human rights. So under promotion of human rights, there are three approaches: building capacities of BHRC, duty bearers, raising awareness, and advising the government. For the promotion mandate, this section of the Gender Ombud Guidelines proposes not so much as rules or guidelines, but a plan of action. For building capacities, there are two main targets for capacity building. First, BHRC personnel, and second, duty bearers in the bar. For BHRC personnel, all new employees will be required to undergo a gender sensitivity training seminar. All newly hired investigators will be required to undergo trainings on investigating gender-based violence and trauma-informed approach to investigation. The Education and Training section, in coordination with the Human Resources section of the BHRC, will integrate gender in development in the continuing education program for all employees of the Commission. At the regional and provincial level, the division heads and the provincial directors will take on a bigger role and a more proactive approach on the following. First, providing a thorough briefing on protocols related to gender-related HRVs and promotion of gender and development. 2, guidance in managing the BHRC helpline or hotline and in establishing the specialized interview room. Third, issuing regular reminders to staff on the importance of adhering to protocols with emphasis on the detrimental impact that could result if the protocols are not followed. And lastly, it is the responsibility of the division chiefs and the provincial directors to continue having regular discussions on how the gender ombud guidelines can be integrated into the daily operations of their office or unit. As part of gender mainstreaming, in the conduct of any periodic assessment by the BHRC, whether it's an annual evaluation or a midterm evaluation activity, the tools for such evaluation or assessment shall include an indicator on the extent that an intervention has been conducted in a gender-responsive and gender-sensitive manner. Gender and development capacity building shall be included in all the learning and development plan of the Commission. And it will be the Human Resource section that shall closely monitor and record training information for all employees on undergoing training, seminars, and orientations on gender and development. Aside from its internal capacity building, the BHRC will also focus its efforts in building the capacities of various duty bearers in the BARM. So it will continue to advocate for inclusion of human rights and basic gender sensitivity training for all BARM personnel. Also, in conducting training activities for duty bearers, BHRC shall focus on human rights standards, principles, normative frameworks, remedies and mechanisms, gender sensitivity, and similar topics. Meanwhile, modules on skills training shall be conducted with due consideration and respect to the expertise of other agencies. So, for example, for GAD mainstreaming and GAD planning, it will be the BWC, or for forensic investigation, it will be resource persons from the NBI or police, and for disaster management, that is gender sensitive, from the BARM Ready or OCD. Okay, in the development of gender-related training modules, it is the education and training section of the promotion division which has the primary responsibility. They shall coordinate with the BWC for development of training modules on gender mainstreaming and human rights-based approaches. They shall ensure that training materials on women's human rights are standardized, updated, and easily accessible by all concerned staff of the Commission. Also, the education and training section shall make use of the current tools and techniques that will give due consideration for the requirements of adult learners or tools in adult pedagogy. So just as a reminder, this is not yet the BHRC's gender mainstreaming plan. So the Commission, in consultation with the provincial offices and key divisions in the regional office, shall formulate a separate gender mainstreaming policy in alignment with its gender and development plan. Raising awareness on human rights, especially human rights of women, is one of the pillars of the Commission's protection work. It is an indispensable element in preventing human rights violations against women. As the BHRC's Gender Ombud, this will be through educational programs and will aim to address the underlying societal attitudes contributing to gender-based violence. The foremost clientele of the BHRC as the BHRC Gender Ombud are the rights holders, or the women. Thus, in designing trainings, workshops, and consultations at all levels, BHRC teams must ensure the participation of women. At the planning stage of each activity, measures to ensure and promote women's participation must be observed. We have included as Annex A of the Gender Ombud Guidelines a publication of the international NGO Oxfam called A Quick Guide to Promoting Women's Participation. It can be used as guide in the conduct of gender-inclusive, community-based consultation. In addressing various perceptions and beliefs that hinder the attainment of gender equality, it is just as important to conduct awareness-raising activities among those who are not usually engaged when it comes to women's human rights promotion, such as religious leaders, traditional leaders, and men and the general public. So in addition to any human rights education or HRE programs being conducted, the BHRC shall include in its strategic communications plan the following. Plan to disseminate and develop education and information materials on GBV, crafting key messages for key audiences, including men, issuances of gender bulletins, as well as responsive bulletins for notable issues of the day, including laws, policies, or programs worthy of commendation, publication and dissemination of reports that are resulting from public inquiries or monitoring activities, community engagement, promoting cultural awareness and sensitivity to address traditional practices that may impede women's rights, utilizing media channels to disseminate information about women's rights, publication of directory of service providers, including VAUC desk information of the various police stations, as well as microsite within the BHRC website dedicated to its mandate as a Gender and Development Ombud in the BHRC, including an online form that could be used for reporting. The BHRC, through its promotion division, shall continue working with the Bangsamoro Darul Ifta in raising awareness on women's human rights among the Bangsamoro or Muslim communities. This can be done through Islamic symposia, integration of women's rights topics in secondary level of ISL teachers or the Islamic Studies and Arabic language teachers, the development of standardized khutbah touching on women's rights, and others. Meanwhile, in indigenous communities, the BHRC will work together with traditional tribal leaders to draw out indigenous concepts relating to human rights and dignity and relate them with common issues being faced by women. In all of these, the BHRC shall ensure that the materials that will be utilized for these purposes are aligned with human rights norms and standards. Pursuant to its mandate under Section 47 of the BHRC Charter, the BHRC has the power to advise the government through various forms. Reports, findings, and recommendations, advisories, bulletins, and others. No? It could also summon the government to explain measures undertaken by the agency on human rights standards. And it could recommend international human rights treaties for signature, ratification, or accession by the government. And lastly, part of its advisory function is submitting annual reports to the Office of the President, the Office of the Chief Minister, and the Bangsamoro Parliament. So to whom is the advice directed? Primarily, it's directed towards the Bangsamoro government and all its instrumentalities. However, nothing prevents the BHRC from providing advice to other actors when such actions or inactions adversely affect human rights. So there are many kinds of advice. These are listed in Section 3 of Chapter 3 under Promotion. So we invite you to look into that list. So as an overall principle, nothing in this chapter on advising the government shall be interpreted to limit the advisory functions of the BHRC. Also, the BHRC does not require the approval of any government agency in order for it to commence inquiries or to provide advice, as it is an independent institution. In drafting advisory documents, staff of BHRC can be guided by the annexes that we have provided. First is on Guide to Integrating Gender in Human Rights Reporting, and the second is Guide to Gender-Sensitive Language. These are provided to ensure that women are not erased in reports and advisory documents to be released by the BHRC. This chapter, still under Promotion, also provides internal protocols on advisory documents for BHRC. So, for all requests for written advice received by any office, including provincial offices, shall be forwarded to the regional office through the policy unit. Afterwards, the policy unit, together with the provincial office concerned, shall discuss the main points to be developed in drafting the advice. For human rights concern of a local or provincial nature, the provincial office shall take the lead in drafting the document, subject to the guidance and review of the policy unit. Meanwhile, for human rights concern of a regional or national remit, the policy unit, in consultation with the protection and promotion divisions, shall take the lead in drafting the advice document. All recommendations and advice are made in the name of the Commission and not of individual staff members, offices, or commissioners. These gender ombud guidelines are shaped by the following approaches and guiding principles. First, it aims to strike a balance between normative frameworks that are shaped by law and those that are shaped by the people's faith and morals. The Gender Ombud Guidelines seek to emphasize human dignity in its work, as well as amplifying voices from the ground, voices that are not usually heard in the national human rights discourse. And lastly, the Gender Ombud Guidelines adopts a cooperative and complementary approach with other fellow BARM agencies and not competition. Okay, so we have come to the end of my discussion on the salient points of the BHRC Gender and Development Ombud Guidelines. First of all, this will not be possible without the continued support from the men and women of the Westminster Foundation for Democracy. Truly, the consistency of their support, the quality of their work, and the clarity of their guidance has propelled and inspired us to push through the process amidst many challenges. Once again, thank you, WFD. Thank you to all of the participants of our consultations, as well as the BHRC staff who have provided their inputs during the development of the draft of the Gender Ombud guidelines. We truly appreciate the effort that you have made in making these guidelines as reflective as possible of the realities of the work of the Commission. From my end, I also thank BHRC in this engagement. It's always a privilege and honor to work alongside fellow human rights advocates. We do not stop from fighting for what is right, especially for the rights of the most vulnerable among us here in the Bangsamoro region. And I hope that we continue to do so wherever we are and whenever it is needed. Thank you very much, and I hope you have obtained knowledge and inspiration from this activity. And with this, I bid thank you and goodbye. Assalamualaikum warahmatullahi ta'ala wabarakatuh.